Hey, how are you doing? Now, today what I'm going to do is I'm going to go over a couple of cases. Now, these cases are vitally important in debt collection cases, be it that you are defending against the debt collector, so they're actually trying to get a CCJ against you, or if you're actually, which you should be doing, is going against them, taking them to court for breaches of data under the GDPR and DPA 2018. So the cases are not from the High Court. So they're not a case law, but they are from the county court, and they are cases of note, cases that have to be mentioned and have to be followed when you actually put them into your hearings, when you put them into your bundles. So they are vitally important, and the judges, their words are still actually very important, even though it's not, like a case law from the High Court or the Appeal Court that comes under the stare decisis, which is setting the precedent, but it is still a strong precedent that is set by the actual judge's words themselves. So it's good for you to be able to know. Now, not many people can find these cases. You have to dig deep, but they are valid cases, and you can use them against the debt collectors when they are coming to chase you, and or you actually going to be chasing them for data breaches, either or. So the first one that I'm going to go over is PRA Group versus Doyle. Now, I will go over, I've got a presentation slides that we will do on them, but basically that they were actually suing Doyle because they believed that they had purchased the debt. But this proves that they had no legally executed deed of assignment. And because they had no legally executed deed of assignment, they have no legal standing. They have no title. They have no chain of title. They have got no proof that they own the debt. Therefore, they simply can't do it. And the judges completely and correctly found that way. Now, remember the cases of Pelias Construction. Okay, so you've got Van Linn versus Pelias Construction, which is a Lord Denning case, where Lord Denning stated point blank that if you challenge the deed of assignment, then the creditor must show you the deed of assignment. Now, I know that the actual debt collectors, the solicitors for them, they twist that around to try and make it, because they also said, well, if you're not challenging the deed of assignment, then the notice of assignment is enough. But when you challenge it directly, and that's what Lord Denning said, when you are challenging directly the actual deed of assignment, then they should show the deed of assignment to stop the argument. Okay. Now, I've got some other videos that I want to do from cases from our group, but I'm not going to do them yet because these ones have been longer established. So I'm going to go over this one. So the first one, right, it is the Doyle case, PRA versus Doyle. I'm going to load up the screen. I'm going to share the screen with you, put the slides on, and we'll go over them. So let me hang on. I'll add that to the stage. I will take myself out of there and go full screen. So, as I've just mentioned, PRA versus Doyle, the case that shook debt collection. Ho ho. So, what this is going to cover, the overview of this, the claimant, obviously, we've just said PRA Group UK Limited. The defendant was Miss Doyle, that was the consumer. This was at the court, which was the county court. As I'd mentioned, it's not High Court, we get that, but still a very important case. And that was in Leeds in 2017. So the issue, did PRA Group prove ownership of the debt? That is the vital question. And that's what they're always trying to get away with, isn't it? They don't have ownership, they can't prove it, but this is what they try and do. So the result, the claim was dismissed. Remember, this was the PRA taking Doyle to court, right, for a CCJ. And the judge, very rightly so, dismissed the claim. No valid proof of assignment. This is what I've been trying to tell people for so long. So what was the core legal question? Did PRA Group have legal standing? All right. The primary issue was whether the PRA Group could prove that it had legal standing to enforce the alleged debt. In legal terms, this means showing it lawfully acquired the right to collect the debt. How do you acquire the right to collect the debt? You have to buy it outright, and it is by a legally executed and valid deed of assignment. Okay? And it has to be a full assignment. So when we look at the assignment under Law of Property Act 1925, it says to enforce a debt, PRA needed to demonstrate valid legal assignment under Section 136 of the Law of Property Act 1925. And this includes a written signed deed of assignment and notice to the debtor. This is what they try and twist all the time, because it says it has to be in writing and it has to be signed, okay, by the bank that's selling the debt. But they try and twist it and say that, oh no, it has to be in writing. That means that our notice of assignment, which is literally just a letter from Fred saying, hey, Henry, you owe us 20 quid. Literally, they try and say that that's what it means. And it does not mean that. The Law of Property Act 1925, Section 136, what it says is it has to be in writing, it has to be signed by the assignor, and under the Law of Property Miscellaneous Provisions Act 1989 on Section 1, it tells you what a deed is. And a deed is signed by the assignor, but also independently witnessed. They never want to talk about that. They only want to talk about the Law of Property Act 1925, Section 136, and they even twist that. All right. So this is the vital issue. Could PRA sue in its own name? In other words, did it have a valid assignment into them? So without a valid assignment, PRA Group could not lawfully bring the claim. And that was the central question that the court had to actually decide upon in this matter. So what evidence did PRA Group produce? Well, what they did was they actually did a reconstituted agreement. So the PRA Group submitted a copy of a credit agreement, reconstructed from data, but no original signed version was presented. That's dodgy to start with, isn't it? Okay. They also had generic data and a witness statement that provided debt details in spreadsheet format. Listen, spreadsheet format. This is what they do. And a witness statement claiming a deed of assignment existed. Who cares what a witness statement says? They need to show proof of a deed of assignment, but they can only ever show spreadsheets. The spreadsheet is them buying block data from these debt websites. It is not a legally executed deed of assignment. So there was no signed deed of assignment. Critically, they did not submit a signed, executed deed of assignment. That is the key legal requirement to prove debt ownership, to prove that there was an actual valid legal assignment. In reality, because they're actually only buying data, they get a spreadsheet of all this information on. They really haven't even got an equitable assignment, never mind an actual legal assignment. So the judge's ruling, no proof of legal assignment. The District Judge Harrison ruled that the PRA Group had not provided valid evidence of a legal assignment under the Law of Property Act 1925. They need a legally executed, validly signed and witnessed deed of assignment, not just a notice of assignment from themselves writing it and saying, oh, yes, we have got a deed. We're telling you, we promise you we've got one, even though they've only got complete and utter spreadsheets of information. And what it means is, right, in legal terms, there is no cause of action. So without a signed deed of assignment, PRA Group had no legal right to sue in its own name. Thus, the claim failed at the first hurdle. So there is no deed of assignment. They did not have a contract. Therefore, there is no cause of action because there is no legal ownership. All right? There is no chosen action. That's what it's called. So debt buyers, if they're buying a debt, they must prove legal title. The judgment reaffirmed that merely producing data or a reconstituted agreement is not enough to establish ownership or enforceability. So laws and principles applied. The Law of Property Act 1925, Section 136, a legal assignment must be absolute, in writing, signed, and with notice to the debtor. And with notice to the debtor, not just notice to the debtor. This is the wording in there, and they try and twist it all the time. And then all of which, in this case, were missing, right? Nothing signed whatsoever. Also, the Consumer Credit Act 1974, for regulated debts, a signed agreement is required for enforcement. If they haven't got a signed agreement, the actual original credit agreement, then they can't enforce any debt. PRA only had the reconstructed ones, the ones that basically they'd made it up themselves, reality. So if I wanted to actually buy a debt, I would go and, like, literally make it up on the spot, and then I could say I owned your debt. This is what they are doing. This is what these debt collectors are doing. They have made a business model on deceit, literally. Now, civil procedure rules in equity, CPR 16.6 and PD 7.8 require claimants to state their case clearly. Equity demands fairness, not just technical compliance. They actually didn't do either. So why this case matters? It's not case law in the High Court, but it establishes the principle. The ruling reinforces that debt purchasers must prove legal title to enforce a debt, not just produce a data or a generic references or, like, spreadsheets that they've went and got from these debt websites. They have to have a legally executed deed of assignment, and they have to show you to prove it. Now, use this in similar disputes. Though not binding, PRA versus Doyle is a persuasive case that you can, where claimants fail to show valid assignment or proper documentation, which you can use and put into your defenses if they're trying to actually take you to court for CCJ, or you can use the same for the showing that they need to have a valid deed of assignment, and if they haven't got one, then there is no legitimate interest. Therefore, they are breaching your data. Okay, so this should be empowering you as a consumer. The case serves as a blueprint for you defending, right? If you're defending them, or you're actually taking them to court for debt, they've got a weak debt claim, and you must insist on the actual legal proof. So, limitations of the case: it is a county court judgment. We're admitting that. We're not trying to make it anything else, right? But it is a decision from a lower court. PRA versus Doyle doesn't carry the same force or the same weight as a precedent, and you can't say because of their case, right, then you have to all follow that same. But it is very persuasive. So it isn't binding, but it is persuasive. It can't compel decisions and saying you must follow it under stare decisis. No, right? But you can still be cited and respected for its reasoning by what the judges said on it. So you put the judge's words in these cases, especially when the facts are similar. Is this debt collector, be PRA or Lowell or Cabot or whoever it is, are they bringing forth the legally executed deed of assignment? No? Well, there you go. This is what happens when you don't do it. Now, it is strategic and it's not authoritative. We get it, right? But you can use this case as part of your argument as in there. Not the whole argument, but you're putting this part in with the rest of your bundle when you go either to defend in court. In our private group, you can see how to actually create them bundles, do it properly, exactly how a barrister would do it. But you can actually use these cases to combine with all of the other statutory rights and other rulings as well, like the Van Lin versus Pelias construction. This makes your bundle far more stronger. So how are we going to actually use it? Challenge the legal standing. Ask for the deed of assignment, citing this case, Doyle or PRA versus Doyle. So we're going to ask for the deed of assignment. We also ask for the original agreement and proof of notice. Demand full proof of the ownership of these debts. Do not just take their word for it. All right. So in courts or complaints, use this case in written defenses. If you're going to make an ICO complaint, right, which I would only do after I'd went to the court, by the way. I wouldn't go and do it before, because they've got a nasty habit of siding. I don't know why. Maybe somebody had paid them, but the ICO a lot nowadays are just actually siding with the debt collectors. But this is a case here going in the county court, but still a court, and still the judge sided there against PRA because they would not provide the legally executed deed of assignment. So you can use this in your ICO complaint. And obviously, you can, if you want to, include it in any SRAs as well, SARs that you're sending off to the debt collectors asking for your debt. So use a judgment and use it to argue that spreadsheets and summaries simply do not prove ownership of a debt. So they are not legal proof of any rights by any debt collector whatsoever. So what we're saying is you need to know your rights. If you don't know your rights and you don't stand on them, you haven't got any. Simple as. So what does it teach us? It teaches that this case proves that the debt collectors cannot enforce a claim without a solid legal evidence, without the legally executed deed of assignment, without the actual original agreement. They cannot enforce the debt. Okay, and if they haven't got them, then they have not got a case. So let me just take this away, remove that one, and me come back in, and there we are. Excuse me. So that case there is showing you, if you actually word it correctly, getting the bundle correctly, but you can still always using, you know, your Van Linn versus Pelias construction, along with that case there, the PRA versus Doyle, and we're going to show you the next one, which just combines it. It's like building bricks, and the stronger you put your case in, or you know, your defense case, if they're trying to sue you, give you a CCJ, right? Or you're actually doing it to go in against them for a breach of data, because if they are not giving you the legally executed deed of assignment, which we're going to go over, then there is no legitimate interest for them to actually be having your processing your data. That is the breach. If there's no legitimate interest, then that is the breach. It isn't just because they're not showing you the data. If they say things like, well, we can't show you the legally executed deed of assignment because under GDPR there's no data on there. That's actually not true either, because it means anything that's related to your debt or your data. But right, what they're doing, what they're saying, by what they're admitting by saying that is there is no data on the deed of assignment, therefore they've got no legal standing and they have no legitimate interest for having your data. That is the breach. You've already got the breach. They've proved it by themselves by trying to hide the deed of assignment. Therefore, they've already breached. That you can actually sue for. Okay, so let's go and share the next one. Again, this is what a lot of people can't find. So that's why you need to get into our group, Checkmate the Matrix. Get into there. I'll put the link in the actual description. We teach these things, we share these things, we research constantly to bring our members these benefits. So that's why you need to get into the group and then start actually learning how to stand on your rights and where you get this information from. Okay, we research it, we find it. And by the way, both these cases, the Doyle one and the Riley one, I'm not taking credit for them because it was actually a solicitor. Really, it was a solicitor that won both of these cases, and it's on a solicitor's website. So this is where we actually can find it. So you can see it on the solicitor's website. I'll actually put the links in the description as well, so you can go and visit it. And it's a genuine solicitor's company that won both of these. Okay, so when you got people that are making comments and say, well, those cases don't exist, can't find them anywhere, well, it's because you don't really research enough, because you're sitting in your van as a fat man, right? That's why you can't actually find the cases, because you don't do the research. All right, you're too busy running after other people. So let's go and share this one, which is the Riley one, which we had mentioned. So if I upload that, get me out of the way again and go to the full screen. So this one, Riley versus PRA Group 2022, legal failure, data breach, and strategic leverage. Let's get into it then. So the case background, we're going to give you that. We're going to give you the legal failures by PRA Group again. We're also going to go over a little bit on the GDPR and data protection implications, because that's where we come from. That's where our group are looking at, because we can actually sue whoever the debt collectors, not just PRA, right? And we're going to compare it with PRA versus Doyle, one we've just spoken about, and we'll also give you some strategic use if it's a legal defense that you need as well. So we're going to show you attack and defend. How good is that? So then, case summary, Riley versus PRA Group, context and court. This one is even more modern, from 2022. County court case involved PRA Group attempting to enforce a debt. The judge ruled entirely against them, striking out the claim and awarding costs, an uncommon outcome in small claims. The judge made the PRA Group pay all of the costs of Riley. Yeah, how good is that? So the judgment highlights the court found that PRA Group had no valid legal title, no enforcement rights, and no proper justification for processing the consumer's data. The case was termed the very definition of unreasonable. Yeah, that's what the judge said. This showed PRA's actions was the very definition of unreasonable because they had no legally executed deed of assignment. They were purely relying on spreadsheets, data, because that's all these people do is buy data. They never legally purchase or buy debt. It never gets legally assigned to them, ever. So the use of this, what we're going to do with it. So it is from a lower court. We're never trying to say anything different. We're not trying to say it's case law, it's precedent, but it is a notable case and it's very important. So you can still use Riley versus PRA Group and because it has got persuasive authority. It's particularly valuable in GDPR and data breach and debt enforcement defenses, all three of them. So that's why we like it so much, because it shows that they had no data. That they had no legitimate interest for having the data, and that's what they're relying on. They're actually tell you all the time. It's one of their favorite things. Their two favorite sentences are, we've given you the notice of assignment and we have legitimate interest. Yeah. So the legal title and assignment failure. No valid assignment. PRA Group failed to produce a valid deed of assignment. Without it, they lacked standing under, again, Section 136 of the Law of Property Act 1925. So what that is, and it states again that the deed must be in writing and signed, right? But they always try to say, oh yeah, it's in writing because we've given you a notice of assignment. That's not what it's talking about. The deed being in writing is what they're talking about. The legally executed deed of assignment, which you will see how it actually gets created under the Law of Property Miscellaneous Provisions Act 1989, where it says it must be in writing, it must be signed by the original creditor, and it must be independently witnessed as well. That is a deed that can then be assigned under the Law of Property Act 1925, Section 136. So they never have anything like this because all they do is buy block data from the internet. Now, chain of title deficiency. There was no evidence showing an unbroken contractual chain, preventing PRA from claiming enforcement rights in their own name. What it means is they can't enforce it in their own name, right? You can have an equitable title as a debt collector, which means as long as, say, for instance, you and Barclays Bank at the same time went to court with a consumer, right? That's equitable title, but they didn't even have that. So they couldn't take it in their own name, excuse me, and they didn't even have enough to actually get the bank to do it. Plus, anyway, the bank's already stated they've closed the actual debt, they've closed the claim. All right. So what is the consequences for you? The absence of legal title nullified the PRA's ability to sue or collect or even process the data, which is what I'm saying. There is no legitimate interest related to the data. Therefore, they are breaching your data. You have a claim under GDPR and DPA 2018. So let's get into this then. Data processing without a legal basis. GDPR violation. PRA Group had no legal title and no contractual link, meaning they lacked a lawful basis for processing personal data under Article 6.1 of the UK GDPR. So, and that also there's a few of them under 6, so I'll not go into all of them there, but that means there's no legitimate interest. Now, they must always be doing a legitimate interest assessment, LIA, but they never do because they don't care. Because all they want to do is concentrate on profit. And literally, this is robbing you, the consumer. Now, let's have a look at what their legal breaches were, what their key legal breaches were. They had breached Articles 5.1a and 5.1d and potentially committed unlawful processing under DPA 2018, Section 170. So they had no legitimate interest to be processing your data. That is a massive breach. You can get compensation for that, okay? So data processing was completely unlawful. All actions involving the debt, communication, storage, collection became data right violations, not mere procedural flaws. So they were massively breaching data. This is a huge compensation win for you if you do it the same way. So this is the thing, a judicial rebuke and costs awarded. So what the judge had said was he was going to award all costs to against PRA in small claims costs awards are rare, but the judge found that their conduct was so egregiously unreasonable because they were trying to enforce a debt with no rights whatsoever, and that justified the fact to award of the costs. Yeah. Why this matters, the judge cited the baseless legal position, misuse of the court's time, and PRA's refusal to withdraw an indefensible claim. So if they haven't actually got a legally executed deed of assignment, then they have got no claim. All right, but they would not they wouldn't have it. They would not have it. So what is the impact for you, and also what happens in the future? This makes Riley not only about legal error, but also about procedural abuse. So you can show the procedural abuse of these debt collectors, which adds weight in future defenses, but also that, not only that, but in when you go and use it for a GDPR breach or a data complaint. So what's the legal alignment for this? Parallel cases, we'd already talked about them. So both cases there involve PRA Group and the representation by local solicitors. And both PRA failed to provide valid assignment. No evidence of a legally executed deed of assignment was ever presented. So that's why I told you before, this wasn't, the litigant in person. This was a solicitor, but all he did was the same as what the litigant in person are doing, was showing them that there is no evidence of a legally executed deed of assignment. Therefore, they do not have any legal standing. So Doyle showed PRA's reliance on the reconstituted records, right? Riley went further, connecting the failure to GDPR and data rights violations. Putting the two together and you putting this into your cases is going to be super powerful. So why Riley matters more when we're talking about the data, Riley expands the legal argument. Not only the lack of title and that they had no legally executed deed of assignment, but it shows you, because they haven't got that it's unlawful data processing. There is no legitimate interest, right? So it's turning the civil debt into a regulatory breach, a breach of GDPR, and that is what you can actually sue them for. So invalid assignment equals a multiple level breach. So they've got no legal title to enforce the debt in the first place anyway, no right to process personal data, as in they've got no legitimate interest. So under Article 6(1)(f) of GDPR, they are massively breaching it, and also potential DPA 2018 criminal liability. And not only that, because of everything that they're doing, that was FCA CONC rule violations. And this is what they're all doing, people. I don't care what it is. It's not just PRA. It's all of these debt collectors. They never, ever legally get the debt. They only deal in data. They buy whole blocks of data. They just have like all of it on the paperwork. They've got no legally executed deed of assignment anywhere. So debt defense claims, all right? Use right to strike out claims where no valid deed of assignment is provided, especially with PRA Group or similar debt collections. Lowell, Cabot, ICA, no, what's it called? ACI, that's it. Link, all of them. In your ICO complaints, if you're going to complain to the ICO, reference Riley to demonstrate unlawful data processing leading to corrective or enforcement actions by the ICO. Again, I would do that after I had taken them to court, only because we've got massive amounts of experience now where the ICO just simply say, oh no, the debt collector said they didn't need to show that, right? There's these cases show point blank, they did. But the ICO, they are not a legally trained group. So I would wait until after I had done the court case, then I would report them to the ICO. So in the data breach claims, which is what we're always pushing you to do, apply Riley in civil suits to claim damages for unlawful processing under UK GDPR and the DPA 2018. This is the exact proof you need to show the breaching of the data. So what happens? The final word. Why Riley versus PRA Group matters, especially when combined to Doyle. What makes it so legally powerful? Because it links the assignment failure directly to unlawful data processing. They are breaching your data. They have breached GDPR. So Riley converts procedural debt errors into data rights violations. They're breaching your data. Therefore, because of breaching the data, you can get compensation from them. This is what you file in court. Make sure you go to the correct court, though. Right? We've spoken about this a few times. This makes a doctrinally sound multi-use authority, a strategic weapon in both defense, if you wanted it, but also counterclaim or even the attack side. All right, so let me get this closed as well. Let's remove that one and put me back into there. It's getting sunny. I'll pull the blind down for you. The sun's coming around the yard arm, which means it glares it a little bit. There we go. So I'll try to hide it from the camera. Excuse me. So there we go. Using those two cases, if you use both of them together, even though they're only from the county court, not the high court, so it's not setting that precedent, it's still incredibly powerful. So if you get them mixed into your bundle, and in our group, Checkmate the Matrix, in the private group, right, it shows you their knowledge share on how you can create a solid bundle to get them into court. And we've got many, many wins. 5,205 is getting mentioned a lot now for these breaches of data and winning against these debt collectors. And more and more and more are coming all the time. Now we've got it. We've set our sights now to push to get it into high court, so we can get new precedents. So instead of relying on Riley with it being in a county court claim, we're going to get them high court claims. We will very soon. But until then, use these cases in there. I'm going to put the links in the actual description so you can go and look at this. It's a solicitor's website. So the solicitors themselves are telling you how they actually did it. And there's the proof of it. We've got it all in there. I only talk about the cases. I only talk about the facts. I'm not going to give you my opinion. I'm telling you what the facts are. And now you can use these in your cases to go against these debt collectors. All right. So have a look in the actual links in the bio for the cases. Also for the actual group, get yourself into our group and you can start gaining all of these wins, getting into our group and getting that knowledge share. All right. Blocking out the sun a little bit because it makes it glary. Okay, till next time, take care and I'll see you all soon. I will. Let's end the record.